Good evening, everyone. Welcome to the guest lecture at the International and Comparative Law Research Center. I'm happy to greet the audience here in person who have gathered at our Library on Public International Law, as well as the internet audience that is with us today as well. My name is Alexey Petrenko, and I am a senior researcher on public international law here at the ICLRC. A few words about us, the host of today's lecture. Our center is a Moscow-based NGO. We conduct legal research on various topics of public international law and seek to promote the knowledge of this field. We offer a number of opportunities, such as different projects that are aimed at developing skills and also meeting people who also work and do something with international law, such as, for instance, the scholarship for young researchers in international law, our prize for the best written paper, international law in the 21st century, and also the famous, hopefully, already today, our summer school on public international law. We are happy, of course, seeing so many new faces today to tell you more after the event, so please talk to us. We'll be happy to share this information with you. So, talking about promotion of the knowledge of international law, the ICLRC offers a space for expert discussion of topical issues related to this area of law, such as ours today. One of the topics of our research focus is international trade and investment, but also general international law. And tonight's lecture is exactly at the overlap of these two areas of our interest. So when we knew that Dr. Miranda is in town, we could not miss a chance to invite him to talk about these issues. So let me present our speaker, Dr. Manuel Sanchez Miranda. He's a renowned specialist in world trade law. His experience includes advising sovereign states and large businesses. Manuel has been actively involved in WTO litigation. He is also a founding partner of De Minimis Law, a Geneva-based law firm dealing with trade law issues. A very cool name, by the way. Dr. Miranda is also a member of the WTO roster of legal experts pursuant to Article 27(2) of the WTO Dispute Settlement Understanding. Manuel is prepared to share his views on economic sanctions and their governance under international law, a highly relevant topic today, as we of course all know. Indeed, economic sanctions are nowadays a widely used tool for foreign policy. Unilateral and collective coercive measures have proliferated immensely in recent years, and their imposition and maintenance have become more of a routine of current global affairs. According to the available data, more than a half of the restrictive measures adopted in modern history were taken in the last decade, and we all know the examples. Moreover, it does not seem that states will stop having recourse to unilateral coercive measures anytime soon, for a number of reasons. Many questions arise about the legality and legitimacy of such measures. And it is for a reason that the United Nations General Assembly introduced in 2025 International Day Against Unilateral Coercive Measures, that is proclaimed to be on the 4th December. A crucial part of the relevant context is the often perceived inability of international institutions like the United Nations and the World Trade Organization, as they are today, to provide the legal framework that could enable states to effectively address these issues, including by peaceful settlement of international disputes. So it seems that there is a need for a comprehensive solution that would consider the existing structures while combining and integrating the respective relevant elements. Dr. Miranda certainly has some thoughts on that and will share them with us today. The guest lecture will be followed by a Q&A session. With that, I am happy to pass on the floor. Thank you.
Thank you very much. Can you hear me?
Yes.
All right. Let me turn this computer on very quickly. Right. So thank you very much for the kind invitation to the hosts of the International Law and Comparative Research Center, and also, of course, Alexei for the super kind introduction. I'm very, very happy to be here. Of course, I'm close to the Russian legal community. I am happy. It's a very exciting source of knowledge, of information. Very intelligent and capable lawyers. I have come across some of the brightest minds in the international law world coming from this country. The topic of today is sanctions. It's not sanctions in general, but economic sanctions. The reason why I started to do research on this because it started when the conflict between Russia and Ukraine started, and you saw Western countries imposing sanctions against Russia, one after the other, to the point that Russia became perhaps the most sanctioned country in the world just after North Korea. And to me, the interesting part was how come these sanctions that seem to be disproportionate, that are affecting not only the state, whatever your take is with respect to something is illegal or not legal, some of these sanctions, they cross the border between state responsibility and the welfare of the regular persons like ourselves. When I come here to Russia, I realize that it's difficult to access the internet. I cannot use my currency. I cannot use my cards. It's very difficult for someone from abroad to purchase goods and services in the Russian territory, to access websites. If you want to buy a flight ticket, if you're located outside of the Russian Federation, it's impossible, literally, to purchase a ticket to come here unless you go through certain airlines that are sort of neutral, like Turkey, for example. I flew from Switzerland to Moscow using Turkey, so I became very curious about what is not only the legitimacy, but also the legality of these sanctions, and trying to understand. So the inquiry here for me was to try to understand when economic sanctions are allowed under international law, purely from a technical level, leaving aside the politics, geopolitics that of course go into the imposition of some of these sanctions, but purely focused on the international law aspect of these measures. And also to understand even if you are entitled to impose some of these sanctions from a prima facie case, then what are the limits on the imposition of these sanctions? Can you go all the way to taking out the Russian Federation, for example, outside of the SWIFT system? I think this is one of those examples where you see, okay, well, this is kind of extreme because now you are affecting the entire population, right? Anyway, so that was the reason why I wanted to approach this topic also coming from a country that is relatively neutral to any geopolitical affairs, like Mexico. I wanted to look at this topic purely from a technical level, as a lawyer. So this is perhaps one emphasis that I want to make before I start making this presentation, that this is a topic that has a geopolitical aspect to it. People study economic sanctions from the international relations world, from a geopolitical angle. Me, I want to make that divide between the geopolitical, the political, and the legal. So here, what we will discuss today is just the legal aspect of it from a neutral, purely technical level. Obviously, I will not go into into issues that are controversial for obvious reasons. But I will go into the technical level of the law that applies and governs economic sanctions, which I think is quite interesting. As Alexei was very well stating, this is one of those areas of international law that merges at least two areas, two subfields of international law. In this case, general public international law, which is the law of the UN, the law that we all know about, the ones that participated in JESUP, that's the general international law. But then also has some subsystems, like the World Trade Organization has some treaties that govern at least indirectly this subject. Like, for example, we will see Article 21 of the General Agreement on Tariffs on Trade contains what is called a security exception that allows WTO members, WTO countries, to impose these type of trade sanctions in certain circumstances. Right? So what I will do now is to explain both sides of this equation and try to paint a picture of how the two of them interact with each other, and also to flesh out some of the problems that I have through the examination of the respective legal regimes. I have understood, I have become to realize that they exist. So let's start with just the primer on economic sanctions. And when I say a primer, just the basics, the fundamentals of economic sanctions. So what are economic sanctions? They are politically motivated, coercive economic measures taken in response to a seeming violation of international law. Right? I want to emphasize two things. So as you can see, they are politically motivated. So as I said, this topic is really about politics and law, right? But they have a relationship with the law, and this is what we're going to focus on today. Some examples that are typical: asset freezes. So for example, a certain company has assets in another country. So the country that is sanctioning the sanctioned state, is going to freeze those assets, right? So they freeze the bank's account. Then seizure of goods. Perhaps the sanctioned country or the sanctioned individual or economic operator has certain assets, like in the form of a building, for example. So those assets can be seized from the sanctioned entity. Investment restrictions, they do not allow certain economic operators to invest in the sanctioning state. Like, for example, some countries they call it the pre-screening mechanism. So, for example, the European Union does not allow that certain economic operators, for example, from China, they come and invest in their territories. If they are Chinese entities, they have to go through a very thorough pre-screening exercise. So those are types of investment restrictions, right? Other one that I think is relevant to the Russian Federation, of course, it's the exclusion from the SWIFT system. So as you know, the SWIFT system is the system that allows private entities, private individuals like ourselves, to purchase goods and services using our cards, using the interbanking system. Like I can use my MasterCard card in any country in the world, thanks to the SWIFT system. And as a result of this Russian Federation being excluded from the SWIFT system, I cannot use my cards, right? They are very widely used by the Western world. Like the United States, they have the OFAC. The European Union, they also have a specific treaty regime that regulates this type of measures. Canada also has its own, Japan, and many others, really. Many others have imposed economic sanctions on other countries. Crucially here is that they do so unilaterally. So these are not systems that have been agreed upon with other countries. They are unilaterally imposed by the sanctioning state. Right? So in this case, the US unilaterally, through its Congress, adopted the OFAC system in order to impose countermeasures or sanctions on countries that, according to the OFAC system, deserve to be imposed that sanction. And the same with the European Union, Canada, Japan, and others. Right? So they unilateral coercive measures. Example, Canada has asset freezes, financial restrictions, import and export restrictions, arms embargo, against some of these countries, right? So you can see, countries that are typically labeled as, that are typically sanctioned nowadays. Now, let's start a little bit into the applicable international law, right? And perhaps to give you, to start with the conclusion in mind of this subsection of the presentation. The applicable law that governs economic sanctions is not very clear. As you can see, it depends on the type of sanction that a sanctioning state is imposing. So is it imposing collective sanctions? Are the sanctions unilaterally imposed? And it really depends on the, therefore, whether they are founded on the treaty, for example, on the Chapter 7 of the UN Charter. They are regulated by a treaty. Then they could also be governed by customary international law, right? And so there really is a regime complex that governs these measures. Crucially, even if there's a regime complex that governs these measures in general international law, there are still some aspects of this governance that are incomplete, that are under development. And that underdevelopment of the legal regime has allowed these sanctions to continue to exist, these unilateral economic measures to continue being imposed by basically some of these Western countries against some of the countries that we have seen in the past, in the previous slides. So it's because of that underdevelopment that these unilateral coercive measure systems, that they exist, not because they are, as we will see, they are not legal. Some of these systems are not legal per se, but they are tolerated because they operate within the gray zone of international law. So let me map the applicable international law. So they are two, if we think about international law sources as the ones that are foreseen in Article 38 of the statute of the court, then we see, of course, you have the treaties, and also you have international customary law. And so I think these two sources of law are the main applicable law to economic sanctions within the spectrum of general international law. So in terms of treaties, you have the UN Charter, like specifically Chapter 7, which allows the imposition of collective sanctions. Then you have the WTO Treaty, which is something that we will look into during the presentation. And then you also have regional security agreements. So some countries have come together and they have created a similar thing to NATO, but regionally, and through that regional security systems, they allow each other to impose sanctions to each other. Like, for example, some African countries, like COMESA, the COMESA region in the African region, contains a chapter or have a framework agreements to allow the members of the COMESA region to impose economic sanctions to each other under treaty law. Then you also have customary international law, which for those who, I see some faces who were in the JESUP, it's always difficult to ascertain the existence of customary international law because you have many ways to ascertain customary international law. Some of the rules that that could be obvious for some, like for example in the JESUP, one of the issues was the principle of no bis in idem, which in my point of view already constituted customary international law, but it's you can actually, as I saw, you can actually have counter arguments to that and argue that this is actually not a principle of customary international law. You can use a deductive method, you can use an inductive method, you can also simply, the courts might say, well, this is already customary international law, and simply state it without implementing a legal test. Anyways, so, and then you also have, this is the sources, and then in terms of who imposes the sanctions, you have collective sanctions and unilateral sanctions. Collective sanctions mean sanctions that are imposed by perhaps more than one country against another country. So you have collective sanctions available under Chapter 7 of the UN Security Council. I don't know if I covered this, but in any case, I'll just go ahead and explain Chapter 7. Some of you already might know, but be familiar with this Chapter 7. But under Chapter 7 of the UN Charter, members of the United Nations can impose sanctions on other UN members whenever they think there is a threat to international peace and security. There's a process that needs to be followed in order for Chapter 7 sanctions to be imposed. Right? So they have to obviously be approved by the Security Council. And of course, you need the voting of the permanent members of the Security Council, including, of course, the big superpowers, geopolitically speaking, and then also other members of the Security Council. Right? So there has to be a decision by the Security Council to impose those sanctions. But whenever the quorum and whenever the voting threshold is met, then those sanctions can be imposed, and there are many examples on this. So there's many examples on this. Sanctions imposed under our Chapter 7. One of them is against Afghanistan, for example. So all the UN members, they voted to impose collective sanctions on Afghanistan. Many other examples, right? So then also within the range of collective sanctions, you don't have, of course, this is the thing with customary international law. You don't have a list, you don't have a treaty or a document that states, what customary international law is. You simply have to resort to secondary sources. In this case, what I think contains the legal regime or outlines very well the legal regime governing economic sanctions, it's found in Chapter 2 of the ILC articles on state responsibility. So you go through that chapter 2, and you will see what are the requirements under customary international law to impose sanctions and countermeasures. And when I think about sanctions under customary international law, I think about countermeasures, right? So then you also have unilateral sanctions. Unilateral sanctions can be imposed. They're not unlawful in and of themselves. Sometimes they are allowed by a treaty. So for example, you have sanctions under the WTO regime. So you have Article 22 of the DSU. You have also Article 21 of the GATT, as I said, which contains a security exception. And also under some bilateral investment treaties contain rights that states can impose on economic operators. Right? For example, DSU Article 22, that's quite interesting. Article 2 DSU of the DSU, that's the procedural the procedural code of the WTO system, dispute settlement system, and it basically tells you that you can impose unilateral sanctions. It's called in the WTO regime, it's called the suspension of concessions or other obligations. But you have to go through a very lengthy process in order to attain that legal right to impose countermeasures. You have to initiate the case. You have to go through the panel stage, which for those who are not familiar with the WTO dispute settlement mechanism, the panel stage of the WTO is essentially the first instance judge or tribunal that looks into an issue, that looks into a case, right? Then the panels will render a decision which can be appealed. A case before the panel stage can last approximately, in my experience, 8 to, I would say, a year. I think a year it's a good average. So it takes a whole year to go through the panel stage. You have to go through 2 hearings to present several sequence of presentation of evidence, and then there's an appeal. An appeal can last between 3 to 6 months. For very complex cases, they have lasted up to 1 year. So it's really a lengthy process. And only until you conclude both of these stages, you can request authorization to the WTO to impose countermeasures, right? Generally, they will be allowed. So if a country has breached WTO rules, and it takes the issue to panel stage and then to the appellate body, at the end, it will be allowed virtually in every single case to impose countermeasures. So it's allowed, But you have to go through, and let me emphasize, you have to go through a very lengthy process and go through litigation, right? So that's a treaty-based example of when unilateral sanctions are allowed. Then you also have unilateral sanctions that are allowed under customary international law. And this is, I think, one of those areas that is underdeveloped, right? So this is what I would mean. This area is underdeveloped, and this is the area that the sanctioning states are exploiting to maintain, build their sanctions programs. There's a clash of titans here. There are two systems that govern economic sanctions that clash with each other. You have customary international law and also WTO and trade law. As we will see, customary international law is underdeveloped. There are certain parameters, even if a country is allowed to impose unilateral sanctions in certain situations, there are still certain parameters that they need to comply with. So we will see that the main requirement to impose unilateral measures is that the sanctioned state has to have committed an international wrongful act. It has to have breached the law, the international law, right? So there has to be a breach of the law. But even if a breach of the law has been committed, there are still certain minimal requirements that need to be complied with, like, for example, proportionality. Okay, it's fine. You can impose sanctions, you can impose countermeasures, but they still need to be proportional, right, to the international wrongful act that has been committed, right? Or, for example, they have to be temporary. Once the international wrongful act is withdrawn, you have to withdraw your sanctions as well, right? So it has to be temporary, right? But then under WTO law does not govern economic sanctions, at least not directly. So there's no article within the WTO legal framework that says economic sanctions, this is the way they have to be governed. No, they are only indirectly governed through the Article 21 of the GATT, which contains a security exception. Right? However, WTO law is really not a forum where you should be litigating issues of global security or economic security or simply just security aspects. The WTO system was created to govern the liberalization of trade and goods between countries. It has nothing to do, in principle, it should not have nothing to do with security issues. However, as we will see, this is one of those paradigms where you have a system like the WTO law where you have compulsory jurisdiction. So you have, the panels and the appellate body, they have the compulsory jurisdiction over any country that is a member of the WTO law, but they are not really equipped to look into the legal aspects of economic sanctions. One of those aspects, for example, is proportionality, right? So they cannot apply the principle of proportionality, right? And so sometimes there is a breach of that proportionality by the sanctioning state, and the WTO tribunals cannot do anything, right? Because it's not part of the legal test. And on the other side, you have general international law, especially customary international law, which can be brought to the ICJ, for example. But the ICJ does not have jurisdiction over all of the countries in the world. Certainly not against those that impose sanctions, like the United States, for example. The United States has not accepted the compulsory jurisdiction of the ICJ. So you cannot bring a claim against the United States for breaching customary international law in the field of economic sanctions, because the US is not a member, has not accepted the compulsory jurisdiction of the ICJ. Countermeasures. These are the requirements that need to be fulfilled in order for economic sanctions to be imposed. First, there needs to be a breach of international law, right? So you need to understand what are the facts of the case, and then you need to understand whether those facts constitute a breach of international law, whatever that breach could be. Like, for example, you could say, well, I don't like that in this country there's a consistent breach of fundamental rights, of fundamental human rights. Like, for example, you can say, well, I don't like that in this country women are not treated equally to men. There's a fundamental legal system that goes against women, and perhaps you can have. That is, if you think that that is a breach of fundamental human rights, then perhaps, and let me emphasize perhaps, that could be a breach of international law. But I don't want to assert that this is the case, because I really don't know whether that would be a breach of international law. But just there has to be a breach of international law. That's the prerequisite to the imposition of unilateral countermeasures. They need to be imposed by the injured state, right? So let me emphasize injured state. So whoever is imposing the sanction needs to be injured by the international wrongful act, right? There has to be a direct relationship between the injury and the international wrongful act. Then, even if countermeasures are allowed, even if the two first requirements are met, the sanctions need to be proportional and need to be necessary, right? Proportional to the international wrongful act. Like, for example, if they have to have a relationship in terms of the nature of the sanction and also the degree of the sanction. They have to have a relationship with the international wrongful act, right? So you cannot just simply say, because you just feel morally bad that things are happening, or because there's a political dispute between two countries, or they don't like each other, the presidents of one country, they don't like each other. That's not really proportionate to anything. There's no relationship between the sanction and the international wrongful act. And they also have to be necessary, right? So if there's alternatives to you before imposing the sanction, then that sanction is not necessary. You have to, if that's the last resort, right? So this diplomacy could be one of those ways. So if you have not, in my point of view, I think if you have not initiated diplomacy mechanisms or diplomacy channels to agree on a solution, so that the country that you think has breached international law withdraws that international wrongful act, if you have not established a consultation process or a diplomacy mechanism to resolve the dispute amicably, then perhaps I don't think that you would be fulfilling the necessity requirement. Right? There have to be necessary, these countermeasures. They have to be temporary as well. Right? So as I said, the purpose of countermeasures is not to punish the sanctioned state. It's not to punish the sanctioned state. It's not about punishment. It's about incentivizing the country that is in breach of international law to stop breaching international law, right? So whenever you convince the sanctioned state to go back to the state of affairs where international law was being respected, that's the moment when you also have to withdraw your sanction, right? You cannot continue it until for an indefinite time, right? So there has to be, this is something like, for example, if someone was sanctioned, is currently sanctioned by the European Union, for example, right? And the reason why the sanction was imposed in the first place does not longer exist. That is a legal ground that the sanctioning entity or government could use to challenge the legality of sanctions. They can say, well, sanctions are supposed to be under customary international law. They have to be temporary. The breach of international law does no longer exist, and therefore I have a legal right to not so that they don't impose a sanction any longer. Right? And lastly, and I think this is a procedural right, but also quite an important one, which is that you have to notify, before you impose a sanction, you have to notify the sanctioned state, and also try to seek an amicable solution. Right? So you cannot just go ahead and the International Wrongful Act is committed today. You cannot impose the next morning a sanction. You have to wait at least a few hours so that you can engage in some type of negotiations. Right? That is a legal requirement. And perhaps, I'm not sure, but perhaps this is also one potential legal ground that entities that are affected by sanctions could use to challenge the legality of those sanctions against them. That the way they were, the procedural, how they were imposed those procedural parameters, requirements were not fulfilled. Right? Crucially, as I said, customary international law, there are certain aspects that are still under development. So these requirements are the requirements of what I think is how things should be, right? But some of these legal aspects are still under development. So I stated that countermeasures need to be proportional, right? But it's one of those very generic, abstract term. What is proportionality? What does a proportionality mean? And I think that this definition can be stated in you can find it in the dictionary, but I think the definition from a legal perspective, it's still under development, or temporariness also as well. I think everybody assumes that they have to be temporary, but what does temporary mean, right? So how long can you keep those sanctions? Can you go a little bit further? The International Wrongful Act has been withdrawn. Do you have to immediately after the withdrawal, you also have to withdraw your economic sanctions, or can you keep it a little longer? For how long? Perhaps because you want to seek for reparations for the International Wrongful Act. Can you do that, right? So there are certain things, there are certain aspects of customary international law in the governance of economic sanctions that are still under development, right? So for example, whether sanctions can have an extraterritorial effect. Let's say, for example, that now one of the issues that we have with the U.S. and Mexico, they want to sanction Cuba because they don't like that they still have a communist system, and they want to put pressure on the alleged dictator that governs Cuba, so that he can withdraw from the government and elections take place, and there's a regime change in Cuba, right? So we know that this is something that some countries, they always like to orchestrate regime changes. And now they want to impose sanctions on countries that trade with Cuba, like for example, Mexico. Cuba received oil by Venezuela for many decades, right? So, and this is the reason why Cuba almost for free, like almost literally for less than the normal value of the oil. It was essentially for free. It was very cheap, right? So Cuba was dependent on that aid from Venezuela, and now that there's a regime change taking place in Venezuela, now obviously Cuba is struggling to keep with its oil needs. And you might think, oil is not as important, but it is really important. A country cannot subsist without oil. Simply, it cannot subsist. Yes, sure, the environmentalists are going to be happy. Now Cuba has to change to renewable energies. But the reality is that we all need, even the sustainability geeks, in myself, I consider myself a pro-sustainability, but I think there is no way to escape from the need of oil and gas. But now, Mexico now has taken over, because on the one side, we see it as a humanitarian aid. So we see also the regional leadership of Mexico is such that in Latin America, at least, I know that for you, you are such a big country, but Mexico is a tiny little country in the world, but it's quite important for the Latin American region. So Mexico has taken over some of that role that Venezuela has been playing, and said, immediately it said, let's send a governmental letter to the Cuban people, to the Cuban government, saying, no worries, we will send you the oil that you were receiving from Venezuela. We'll send you at least some of that oil. We don't have as much oil as Venezuela has, because Venezuela has so much oil, but we do have some oil. So we wanted to send. So Donald Trump, and sorry if someone who is here listening to us is working for the Trump administration, but I'm just stating the facts that are public here. I'm not. Now they want to impose sanctions on those countries that send oil to Cuba. And Mexico is like, well, what's going on here? I mean, that's extraterritorial effects of those sanctions. I have not committed an international wrongful act, and you're trying to impose sanctions on me when I have nothing to do with whatever you're doing. So that's an example of extraterritorial effects. Third-party countermeasures means that there is a collective obligation, like for example, the erga omnes obligation not to commit a genocide, right? So that's already attained, I think, the status of customary international law. It's an erga omnes obligation not to commit a genocide. So whenever a genocide has been committed, then a collective obligation has been breached. And as a result of that, countries are allowed to impose so-called third-party countermeasures, right? So let's say that the erga omnes obligation, that the genocide has been committed not against a particular group of individuals within a country, so simply across the entire territory of a country. And so that really does not affect sometimes the sanctioning entity, the sanctioning countries. But the breach is so severe that even if none of the nationals from the sanctioning state have been killed in that genocide, collectively the world has a right to impose countermeasures to the genocidal state, simply because it's erga omnes collective obligation being breached, right? So those are third-party countermeasures. Now, it's very clear whenever you have an issue that constitutes an erga omnes breach of obligations, right? Or a breach of an erga omnes obligation. But the truth is that these third-party countermeasures are sometimes not, they don't result from this type of very severe breaches. Sometimes there's no relationship between whoever the state that is imposing the sanction and the state that is being sanctioned, right? So sometimes there's a breach. There may be a breach. There might be some states that are injured by that breach, but another state says, okay, that breach does not affect me directly, but because I'm an ally of that state, I'm going to impose sanctions. Right? This is so typical nowadays with everything what's going on. Right? So that's called third-party countermeasures when a collective obligation is breached, right? or allegedly breached. Then I would also admit that another aspect of customary international law that's still in progress is whether serious breaches of international human rights or international humanitarian law have been breached as well. I think international law is heading in that direction, where whenever a serious breach of international, a consistent, systematic breach of international human rights are being violated, then eventually you will be, I think, in a couple of decades, I think the development of the law is heading in that direction. But nowadays, I would say that these three types of sanctions that have extraterritorial effects, sanctions that are third-party countermeasures as a result for breaches of collective obligations, and sanctions for serious breaches of fundamental human rights, they're still under development, right? So what does this mean in practice? For the sanctioning state, that means that they can operate they can impose these three types of sanctions. That could be the legal grounds that they use, or the rationale that they use to impose their sanctions, and basically they can get away with it, right? That's a critical aspect of it. So we will see it's more and more that these unilateral sanctions, they are imposed in one of these three modes. Now, how much time do I have? Well, 15 minutes? Okay. So as I said, unilateral sanctions under the WTO can also be imposed, but I think I'm not going to go through all of it. But as I said, in order to impose these restrictions, these sanctions under the international law, you have to go through the panel stage. There has to be 1 or 2 years of litigation, and only then you can impose a sanction. With that being said, and I think this is kind of one of the most interesting aspects, and I'm going now entering into the area of international trade law. The WTO regime contains a security exception, which is foreseen in Article 21 of the General Agreement on Tariffs and Trade, right? So the text says that nothing in this agreement shall be construed to prevent any contracting party from taking any action which it considers necessary for the protection of its essential security interests, taken in time of war or other emergency in international relations. So whenever there is a breach of WTO rules, then countries that impose one of these sanctions or countermeasures, they can invoke the security exception to justify their otherwise unlawful trade restriction. Right? Let me break down the legal test under Article 21. Is there a war in international or emergency in international relation, which is the one that we can find here, right? In Article 21b3, the measure has to be taken in time of war or other emergency in international relations. Has the measure been imposed in times of war or international relations? So not only does the emergency in international relations should exist, but the measure itself must have been adopted exactly when that measure was taking place, right? So there's a timing issue, there's a timing requirement. And whether the sanction protects essential security interests of the sanctioning state. Right? This is foreseen in the chapeau of Article 21b. So to prevent any contracting party from taking any action which it considers necessary. So it's a subjective decision. They can decide what they consider as necessary for the protection of its essential security interests. The bottom line here is, and that's it. There's no proportionality test. There's no requirement that the measure has to be only imposed temporarily. There's no need for negotiations to have taken place. All of these requirements that I painted here when describing the state of the legal affairs under customary international law for this type of measures, it's applied in WTO law. Right? So the legal test is far more lax than customary international law regarding the requirements to impose economic sanctions. WTO tribunals are not obliged to assess compliance with the broader customary international law requirements. So that leaves really a gap in the legal governance of these measures. And this is why what I call trade weapons can be imposed. That means imposing trade embargoes, sanctions with extraterritorial effects, measures that are trade restrictions that are excessive, or sanctions that are against entities or subjects that are not responsible for the international wrongful act. Right? So you're imposing a sanction against an entity or an individual that has nothing to do with the international wrongful act. So we have seen a lot of the the list of sanctioned entities or individuals in the EU list, sometimes they have nothing to do with the reason why they were included there in the first place. So they have absolutely nothing to do. They're just sometimes expressing their opinions as intellectuals. So some professors are there because they don't think in the same line of thought as the European Union leaders, for example. So trade restrictions imposed under dubious security grounds as well. So one country might say, well, this is a economic security issue, but in reality, it's just a capricious measure. Like the United States now, they want to claim that everything amounts to a economic security issue, when in reality, it's just a capricious way of protecting their domestic industry in a way that is unlawful under WTO rules, which do not allow discrimination, for example. Or importantly, and perhaps this is one of the last slides that I will do, is that you must identify, first of all, as I said, the first requirement is to identify whether the relationship between the sanctioning state and the sanctioned state. So here in this diagram there's 5 countries. So we have country A, which is the country that's imposing the sanction. And this country is directly injured by the international wrongful act. Then country B is a sanctioning state that is not directly injured, right? But they are still imposing a sanction. Then you have country C, country D, and country E, which represent countries that have been sanctioned, right? So country C has breached international obligations, right? So they are indeed in a breach of obligations. Then country B, but vis-a-vis international obligation. So for example, country C has breached an obligation with respect to country A directly, right? So bilateral breach of obligations. And then you have country B, which is a sanctioned state that has breached communitarian obligations, like erga omnes obligations. They have, for example, committed a genocide. No? That would be the situation of country D. Country E, they are sanctioned states that do not breach international law, right? But nevertheless, they are sanctioned without breaching international law, right? So when do the sanctions become what I think are trade weapons? I mean, trade weapons are measures that they will be unlawful under general international law, but somehow because of the gap in the governance under WTO rules, and also on the one side and on the other side, because you cannot sue before the ICJ some of these sanctioning countries, right? So that's what I call trade weapons. So when do sanctions become trade weapons? So let me see. So they are inherently unlawful scenarios, which is when you have these three scenarios. When country A, the sanctioning state that is directly injured, imposes a sanction against a state that has not breached international law. That is an unlawful scenario. So country A is breaching generally international law, customary international law, by imposing a sanction on country E that has not breached international law. Then you have country B, a country that is imposing a sanction that is not directly injured. And I said injury is one of the requirements that you need to fulfill as a sanctioning state in order to impose a sanction or a countermeasure. You need to be injured. So country B is not injured, right? They're not directly injured by the International Wrongful Act, and they impose a sanction as well against a state that has not breached international law. That is scenario 6, I think, is also one of those scenarios that are in breach of generally international law. Another one is when country B, a sanctioning state that is not directly injured, imposes an obligation against country C, which has indeed violated international law, but that obligation is not owned to country B, only to country A, right? And that's the reason why I consider this country B as a non-directly injured. Those are, in my point of view, inherently unlawful under general international. They're always unlawful, right? But then there's other scenarios which are not, they could be unlawful, right? They could be lawful, but they could be unlawful, right? Depends on whether the other requirements that I described are fulfilled or not, whether they're proportional, they're necessary, they're temporary, etc., right? Those could be when country A, sanctioning state that is directly injured, imposes a sanction against country C for an international obligation that is owned to country A. In principle, they should be okay, right? So in that scenario, country A should be entitled to impose countermeasures. However, they could surpass the legality of international law if they do not fulfill these requirements, as I said, of proportionality, necessity, temporariness, and if they have not fulfilled the procedural requirements. Right? Then you also have in a scenario like scenario 2, the sanctioning state is directly injured, and that state imposes a sanction on the state that has breached communitarian obligations. As I said, one clear example is when sanction A imposes a sanction on a country that has committed genocide, right? And then you also have country B, which is a sanctioning state that is not directly injured, only indirectly injured against country D. That in principle should be okay because there's a violation of a communitarian obligation. So that in principle should be okay, but again, you have to meet the requirements of proportionality, necessity, temporariness, and also fulfill the procedural requirements. Right? I will share these slides with you because so that you can. This is quite. Now, what I think are the main reason why this unilateral coercive measures systems exist, where these sanctions continue to exist and until, it's because of there's three misalignments, right, in the governance of these sanctions. And until these misalignments are remedied, these sanctions, these systems will continue to exist, to evolve, to build up. And I find three misalignments, right? So the first one has to do with the applicable law, right? So the applicable law between general international law and international trade law, or the law of the World Trade Organization. Unlawful trade weapons, which, as I said, trade weapons would be unlawful under general international law, they still can be justified under the WTO security exception, right? So disproportionate trade weapons can be justified under the WTO rules because the proportionality test is not part, in principle, of the legal test under Article 21. Okay? And let me emphasize why it's so important that WTO system as a legal system, because the WTO has jurisdiction, is the only international court in the world that has jurisdiction over all of its members. So members that are immune, in principle, to the surveillance of the United Nations, of the Security Council, the 5, for example, permanent members, they are subject to the jurisdiction of the WTO tribunals. Right? For example, the U.S. imposes so many sanctions. You cannot challenge those sanctions before the ICJ, before the International Court of Justice, but you could initiate the WTO case to get rid of that sanction. But the problem is that the U.S. could use the narrow scope of the security exception to justify and get away with it, basically. As I said, sorry to anyone who is friendly with the Trump administration, but I'm just stating the law being strictly technical here. There's tensions with, the principle of non-intervention, of course. There's a tension with the principle of abus de droit, with erga omnes obligations. And there's a conflicting jurisprudence between the ICJ and the WTO, precisely because the legal requirements that need to be fulfilled in both of these forums are different, right? As I said, there's also the other misalignment is that the WTO, even though it has compulsory jurisdiction over all of its members, they don't have the ability to apply general international law. The ICJ, on the other hand, has the ability to apply general international law, but does not have compulsory jurisdiction to examine trade weapons adopted by the United States and the others that impose economic sanctions, right? So there's a misalignment. And there's the third misalignment is on the institutional designs of both the WTO and the United Nations. It is unclear, really, whether the WTO should deal with collective or security issues in general, right? So the WTO was not really created to discuss or to handle economic security or security issues, right? It's only, as I said, indirectly that there is an Article 21 in one of its treaties, and it's through that all these security issues are being channeled. But the nature, that is only 0.001% of the legal body of the WTO system. The rest is all about how to liberalize trade, how to allow that goods and services from one country can go and be exported to another, can be imported into your own country. That's all about that. The WTO is for liberalizing trade, not for security. However, now the security exception is being invoked over and over by many of these WTO members, not only by the US, but now some countries have used the security exception for things that have nothing to do even with essential traditional security issues. They call it now economic security, right? So what is economic security? And you will read it in the news. It's a new concept that I think is just an invention of the creation of a narrative that didn't exist before. And now they're trying to frame it as a security issue, but it's really not a security issue. It's just a desire to protect your domestic industry under these guise of a security issue. As well, there's no interinstitutional channels between the WTO and the UN to discuss these issues, right? So the UN should be the forum where security should be handled, and all the security, this is the reason why the UN exists in the first place, right? You have a chapter 7 that deals specifically with international peace and security. So the proposed solutions, it's to reform the WTO treaty or change the trajectory of WTO jurisprudence in order to take into account the basic requirements of general public international law. This is actually something that in the summer school of last year, I was a guest here to speak in one of the lectures. At the end of my presentation, we did an exercise, and this is precisely what I tried to do in that exercise. How using the text, the very narrow text of Article 21, you can actually build a bridge between, the proportionality test, bring that proportionality test into the WTO system, and through the WTO system, try to, control, to put some boundaries on these trade weapons. Clarify, the members, WTO members should clarify what is the jurisdiction of the WTO tribunals over collective security. If the world becomes more and more securitized, there is much more need for that. So WTO members should come into a room and decide whether the WTO, I know that the WTO was not created to deal with the security issues, but the reality is that now they are starting to deal with these type of issues. So let's try to equip them with the right tools so that those proportionality tests, timeliness, all of those very important customary international law requirements for these type of measures are also imposed or considered in the WTO regime. So clarify the jurisdiction of the WTO tribunals. Create as well a committee, a WTO committee on national security. I think it's very fair to say that if trade is now being securitized, there's a need as well to create a committee within the WTO to deal with these national security issues, right? As well, to establish institutional channels between the UN and the WTO for cooperation and information, because security is, all these trade weapons are indeed discussed in the UN, but the people from the UN, sometimes the actual delegates, and they're not working in the WTO. Sometimes the WTO has no idea. They live in a bubble. Both are bubbles, and they don't interact with each other. So they have to interact with each other. They should allow the topics to be cross-cutting. So what are the main takeaways? Delineating the boundaries of what is lawful and unlawful is a complex task. Even if these boundaries can be drawn, which I think can be drawn, and this is kind of the argument that I advance here, that they can be drawn, those boundaries. Misalignments between WTO law and general international law make it possible to justify otherwise unlawful trade weapons under the WTO security exception without judicial or institutional oversight. Owing to this inadequate governance, countries have been able to impose and maintain unlawful sanctions without consequences. So there's a need to resolve the misalignment. Thank you very much. That's it for me. So now, if anyone has any question or comment, I am very happy to take some questions.
Okay. If possible, could you please also introduce yourself so that we know you better?
Okay, I'm Andrei Loginov, a student of High School of Economics and International Trade. What do you think? Is it really possible to change WTO jurisprudence to take into account basic requirements of general international law because of Article 3.2 of the DSU, meaning that dispute settlement body cannot add or diminish rights and obligations under agreements?
I think it's possible. Yeah, it's very possible. Actually, this is as I said in the last summer school, I did this exercise. Through interpretation, you can definitely try to squeeze in, some of these proportionality tests, for example, to bring it into the WTO law. It's just about being creative in just half-an-hour exercise, the students were able to come up with some possible avenues to do that. So it's definitely possible. So to do that, you will have to look at the text of Article 21. So you have to look at the text of Article 21 and see how you can squeeze, some of these requirements from international law. I mean, you can say, for example, I think necessary, the term there, necessary, which it considers necessary. I think there's a necessity requirement there, right? And I think that if you can argue, for example, that if something is not proportional, if a sanction is not proportional to the breach of international law, then that may not be necessary, right? So you have to be a little creative, test the system. Of course, I don't know what the outcome of that argument could be. It has never been brought to the WTO tribunals, but definitely even though there's a narrow legal test here, you can try to use the wording of this in order to interpret some of these terms in a way that those requirements from customary international law can be brought into WTO law. I would say, yeah, it's possible.
Hey, my name is Gregory Dress. We're already acquainted. I'm from Financial University under the government of Russian Federation. So you have already said, you have already mentioned this necessity criteria and also the erga omnes trend both in the WTO and the ICJ recently. So my question is, you said that the test can be made, but generally, if we assess, the perilosity of the situation for the state, generally it may be interpreted like any instability may be interpreted as kind of perilous for the state, whether it's a war or a revolution, I don't know, 3 seas abroad. And what exactly, that's what I'm asking, what exact criteria may be made to assess this necessity, to gauge it? As you know, now, these days, many obscure arguments are made, as good as, smuggling poor quality cocaine. Yeah, so yeah, that is my question. Thank you.
That's a great question, and to be honest, one that is still under development. But I would say necessity means that there must be no alternative measures that are available for a country in order to achieve what you're supposedly going to achieve by imposing a sanction. So the purpose of the sanction is to incentivize the state that is breaching international law to comply with international law, right? So it's just not to, as I said, it's not to punish. The state per se is to incentivize, to make it to incentivize it enough so that that government can have an incentive, enough pressure so that they can return to the state of legal affairs. So if, for example, the country has, the sanctioning state has on any other alternative measures that are less restrictive than imposing the sanction, then in that case, that would be a breach of the necessity test. So if there's an alternative measure that is less trade restrictive, that is restrictive. And I think proportionality also is very much related to the necessity test. Because I think proportionality also, if something is not proportional, that means that you could have adopted perhaps a similar measure that is less trade restrictive. Perhaps instead of imposing an extra duty of 500%, you could have imposed a sanction of 100% customs tariffs. And that should be enough, right? So it was not necessary to go all the way to impose a trade embargo. You could have just added some extra customs duties on specific products, right?
Very quick follow-up. WTO law is not really my realm. However, so I'm asking, were there any cases for this reciprocity, proportionality, proportionality, and were there some, have some exact metrics been used to assess whether something is proportional or not? Yeah.
I think there's been cases, to be honest, no one that comes to my mind, but there's definitely been, I believe the Nicaragua case, with the proportionality test of a countermeasure. Yeah, but there's been cases on proportionality. And also you can find in the chapter 2 of the article, ILC articles on state responsibility, what proportionality means.
If I may maybe intervene a little bit, and for a change, to remind that we also have people listening to us from the internet, and they also have some questions. But we'll go back also to the questions from the audience as well, because we know that some already have indicated interest. So several questions, so I will read them out. The first one actually is from so it's asked by Alexei Kachanov. And I guess it refers to one of the points that you have addressed in one of the screens in your presentation. What role do you think the principle of non-intervention has in the sphere of using unilateral measures? Do we need this principle for detecting and describing unlawfulness of states' action?
Well, it has a very strong relationship. You know, if imposing a sanction means intervening in internal affairs in a certain degree of the country that's been sanctioned. So, of course, imposing that sanction would definitely breach, I believe, the principle of non-intervention, right? So you shouldn't be imposing a sanction just because you feel like you don't like the precedent, right? So if you don't like the precedent, this is what's happening now. So some countries don't like the precedent of another country, and based on that, they're imposing a sanction and trying to affect the direction of internal affairs. This is exactly the reason why sanctions are regulated, because those type of countermeasures, those type of sanctions should not be imposed. They are illegal because they amount to a breach of the principle of non-intervention. So, like with Cuba, for example, that's a great example. Cuba has been, of course, you may agree or disagree with the legal regime of Cuba, right? But it's Cuba's legal right to self-determine what they want. Of course, as I said, you might disagree with the legal regime there or the system there, but ultimately, imposing a sanction, I think that would be imminently a breach of the principle of non-intervention.
Thank you. I guess we have another question, and then we can switch back to the floor, but also coming back because actually a number of questions is asked. So the next question comes from Innocenty Karandashov. Dear Manuel, thank you for the lecture. You said that the ground for the application of sanctions is a breach of international law. But what if a sanctioned state and a sanctioning state actually have different positions on whether the breach actually took place?
Right, that's a very great question. That is a very great question. This is the thing. When you have a forum like the ICJ, if the sanctioning state would have accepted or has accepted the compulsory jurisdiction of the ICJ, you can bring a case to the ICJ to determine that question. But since, generally speaking, the countries that impose the sanctions are not part of the ICJ, they have not accepted jurisdiction of the ICJ, it's difficult to assess that, right? So you leave it to each state to decide whether certain action constitutes an international wrongful act or not. And so this is part of the misalignment, right? So and also the fact that some of the law is underdeveloped. If they disagree, well, let's say hypothetically, that the sanctioning state and the sanctioned state, they're both part of the ICJ, just for the sake of argument. Both countries have accepted the jurisdiction of the ICJ, and they have brought a case to the ICJ to clarify whether certain action constitutes an international wrongful act. I think that would solve the problem that is presented by this question, right? So, but if they disagree, then I think in practice you cannot do anything. But you know, and I think in practice it happens a lot that countries disagree whether there was a breach of international law or not. It's really sometimes that, however, let me emphasize this as well. This is something that we focus on general international law and WTO law, but then a lot of sanctions litigation is taking place as well before the European Court of Justice, and these cases are brought not by the states but by the sanctioning entities, like for example some individuals or companies that were put in the sanctions list. Right? So those individuals and companies, they initiate the case before the European Court of Justice, and one of the things that they could litigate and dispute is whether an international wrongful act has been committed or not. Right? So that's another channel. If these are sanctions imposed by the European Commission, right? I believe that, I mean, I'm not an American lawyer, but I suppose that also you have similar mechanisms on the US law. So you could leverage US law, US domestic courts in order to challenge the legality of those sanctions if, in case, you know, an individual or economic operator considers that there was really an international wrongful act in the first place.
Thank you. Nikita.
Good evening. My name is Nikita Pestikov. I'm a law student at Irish School of Economics, and I actually have two questions. The first one is regarding, is it actually even possible to enact unilateral sanctions under WTO law, since you've stated that to enact this security exception, you need to go through all the stages of the dispute settlement, and as you know, I assume that the opposing country will go to appeal, and we know that the appellate body currently is not
Functional.
Not functioning. Yes, unless of course both parties are going through the multi-party interim arbitration. And the second question is. I don't know if you know or not, but it's quite curious, since the next ministerial conference will happen next month, if this question will be one of the topics that they will discuss. Thank you.
Great questions. So on the second question, no, this topic is not part of the agenda as of, you know, as I understand. I don't think it will be part of the agenda in a period of time, I believe. But hopefully it will. Hopefully it will. I think there's a lot of. I think, you know, the world is really very geopoliticized at the moment. So I think things have to calm down before these issues are really, you know, people will agree on these security issues, right? So I think eventually we will see these discussions taking place. Eventually we will see an operating appellate body, I believe. But as of today, I think these topics they will remain like this. You know, the geopolitical tensions are just building up. And we don't know until when and how they will develop over time. But as of today, I don't think the WTO members are ready to discuss this type of issues, especially in the trade world, you know, because the trade is not supposed to be governing security issues. On the first question, well, definitely it's possible to bring a claim. It doesn't have to be an economic security measure or not. Simply, you know, for those who are not familiar with the WTO legal system, so there's the dispute settlement mechanism has two levels. So the first instance is called the panel stage, and you can appeal a panel stage panel report and bring it to the appellate body, which is a standing body of judges. Currently, the appellate body does not have judges because decisions in the WTO are taken by consensus. And as of today, there is no being consensus on the nomination of new appellate body members. You know, they have finished their term. Normally, they would finish their term of 4 to 8 years, and then a new individual will take his role or her role. But since the Obama administration, the US has rejected new nominations. And as a result, from 11 members, today there is no member, so the appellate body is completely empty. Right? So all of the appeals that are made by WTO members of panel reports, they go into what I call into the void. They are appealed and they go into the void. They exist. There's still a case whenever the appellate body returns to activities. Then eventually those cases will be reviewed by the appellate body. But as of today, the appellate body is not operational. And so that problem affects not only measures or cases that involve trade weapons, but also any type of trade issue, right? So, and there's also this temporary mechanism called the MPIA, the multi-party interim arbitration. So it's essentially an ad hoc appeal mechanism, very unique to the world of international dispute settlement. Very, very unique. I mean, generally appeal bodies, they are standing bodies. They are always there, but these are ad hoc appeal mechanisms, and that's quite unique actually. I really love that from the WTO, but only so that mechanism, that temporary mechanism, allows for the appeal of cases without a panel report going into the void. Because instead of being reviewed by a WTO appellate body, it will be reviewed by one of these ad hoc appeal tribunals. As long as the parties involved are both part of MPIA, are both part of this mechanism. What's happening now is that some of these cases that are appealed, but only one of the members is member of the MPIA, and the other one is not. So in those situations, it still goes into the void, right? So thankfully, a lot of members are part of that. So the UK is part of that mechanism. The China is part of that mechanism. European Union is part of that mechanism. So really powerful, countries that actually sanction states are part of that mechanism. Mexico is also part of that mechanism, proudly. Any other question? Perhaps there.
My name is Elizabeth Angeli. I'm the law student of the Kudafin Moscow State Law University, and my question is following. So you have mentioned that the final aim of the sanctions, of imposing sanctions, is not a punishment. It's more like preventing from the unlawful behavior, if we can say like this. So what are the criteria, what is the line between punishment and the preventing from the unlawful behavior?
Yeah.
Thank you.
Also, great question. And actually, I appreciate when I have questions like that. Well, that is really an open-ended question. I wouldn't be able to tell you exactly what are the legal tests to do that. But, like, for example, something that would be punishment would be if certain assets are frozen by, say, a state-owned company from the state that allegedly has committed an international wrongful act. So those assets are frozen. If that state-owned company somehow has some type of relationship with the international wrongful act, perhaps there's a legal ground for those assets to be frozen, right? But it would be a punishment to get those assets forever. You can only freeze them. You cannot take them forever because that would amount to a punishment, right?
So
that's a good example, I think.
So can we assume that if we have a chance to have litigation or some negotiations, for instance, about the assets, it is a sign for us that these sanctions are not the punishment, as long as we have a chance to go, for instance, to the arbitration or something. So it's just our chances to maybe have our assets back. So
yeah, exactly. It would have to be through. Let's say hypothetically that the international wrongful act has ceased to exist. There's no longer an international wrongful act. Let's say that there was a state was breaching fundamental human rights, but now the state has taken some political responsibility, accountability, and says, I'm going to reform, I'm going to change the state of affairs in my country, and a new president comes to force and then say, I'm going to fix this. I'm not going to longer breach these fundamental rights. And they do actually change, right? So that unlawfulness no longer exists, right? So if the breach has been withdrawn, it has ceased to exist, then the country that is imposing the sanction has to release the sanctions. That's an obligation. If they don't release the sanctions, then of course there's a breach of customary international law, because they are punishing, they are taking the measure. The effectiveness of the measure has been extended beyond what is legal, right? So you would have to, through litigation, challenge that. But normally you would do that before domestic courts. If there's if a state is part of the ICJ, then you can go through the ICJ. If you are, it also depends on who you're representing. Are you representing the state? Are you representing the individual that's being sanctioned, or whose assets have been frozen, or the company, the state-owned company that has seen their assets frozen? Depends on the sort of like the strategy that you want to follow. You can go through the ICJ if it's a state to state. It can be domestic jurisdiction courts, and then it also depends on the relationship between the municipal law, the domestic law, and international law, right? So if you need to have a bridge between, to bring this proportionality test or to bring this temporariness requirement into a legal ground to challenge the legality under municipal law. And this is something that does not exist in domestic law, but only in international. Then somehow you have to find a link between the two systems to bring that international law requirement into domestic law litigation. But I think ultimately, if once the International Wrongful Act has been withdrawn and things have come back to the normal state of affairs, judges will, I would be surprised if they continue imposing a sanction. But definitely litigation, we will see a lot of litigation in the future. Now, once an International Wrongful Act has been withdrawn, but yeah. You can leverage domestic and international courts.
So, well, unfortunately, I must notice that we are coming close to the end of the lecture, but since I see that there are some questions, so I propose that we will take one question from the audience and the second question that would be from the internet, and then that would be it in accordance with the plan. But we'll have some time, at least for those who are present here, to continue networking, because we have prepared some drinks and snacks afterwards, but it is for later.
Thank you for giving me an opportunity. So my name is Paulina. I'm a High School of Economics Lyceum student, and I would like to thank you for your wonderful speech, wonderful presentation. And I have a question about proposed solutions. So one of those is the creation of WTO Committee on National Security. And my question is about, are there any discussions or debates or, conferences on this topic? Are there any plans on really creating, founding this committee? Is it realistic or just a plan? Thank you.
That's a good question. I think there's been some proposals in that sense, but I don't think the proposals have taken force. Because as I said, it's not an issue of relevance. It is relevant to create such a committee. It's just the timing. It's just such a geopolitical world right now. So I think, so what happens now is that these issues are discussed. For example, if the sanction affects trade in services, like for example, exclusion of a certain country from the SWIFT system, that affects the services trade. So it would be brought before the services committee in the WTO and discussed there rather than in a national security committee. Or if it affects trade in goods, perhaps because you impose a trade embargo. So that would be on goods. So that would be discussed in the committee on goods, right? So they are discussed, but just not in an appropriate channel. And I think also having a specific committee on security or national security or security trade-related security measures would make a lot of sense, because it simply makes it explicit that these measures have a security component, right? And So I think it would be a step in the right direction. But as of today, there is no such committee. There's been proposals worded by some WTO members, but the proposal has not really taken force.
Okay, so we have one more question from online. This comes from Polina Tankir. Dear Manuel, thank you for your presentation. The notion of politically motivated unilateral coercive measures changes these days. Similarly to trade protectionism under the guise of climate measures, some economic sanctions are in reality not politically motivated, but rather economically motivated by the desire to outcompete some other countries' international markets, which is sometimes openly stated in some national security strategies. Do you think there are any solutions to this problem? Further clarifications of security exception provisions under the WTO law, for instance, could they work?
That's a great question. Wow, I'm surprised how great questions, honestly. Yes, there is something that can be done, but it depends, right? It depends on the circumstances. Because if we go back to the legal test under Article 21, you will see that there are certain requirements that need to be fulfilled. One of which is that they need to be adopted for the protection of their essential security interests. And there also needs to be an emergency in international relations. What we're seeing today is the buildup of a narrative, a new narrative that did not exist before, of so-called economic security. So now, like when I read that term in the news for the first time, I was surprised what's economic security? I mean, I always thought security was just security in a traditional way. You know, there's a military conflict between two countries, or there's something really, you know, that really has to do with disarmament issues, things that are really connected to security. And economic security, especially the way it's being built up today, has really nothing to do with that traditional concept. So if you see what, you know, the sanctions that are imposed by, you know, not only by the US, now also the European Union has imposed countermeasures. Then China and the US are in a trade war. And then some countries, whenever they are sanctioned by the US, they also take countermeasures, right? So there's a, and all of this is, I think that builds up into and legitimizes this concept, this notion of economic security, right? So even though that might not in principle, economic security might not in principle constitute an essential security interest, because countries nowadays are interacting with each other and imposing sanctions based on economic security as well. This is something that really just existed in the US narrative, but now it's something that exists also in the European Union, for example. Now the European Union has its own office specialized on national and economic security. Australia as well has a law and a regulation on this, and a lot of countries have now new laws and agencies within their internal governments that deal with economic security. So I think that that securitization narrative that has been endorsed by other members, and not only it was initiated by the US, but now other members are also adopting the same narrative. So I think that has legitimatized and also made it easier to maintain these trade weapons. Because now before there's jurisprudence that confirmed, like it's a jurisprudence by the WTO in a case against the US for sanctions on steel and aluminum. Sanctions, right? It's not really sanctions, it's just unilateral restrictions, trade restrictions, against many countries. One of them is Switzerland, where it said that economic security issues do not amount to an essential security interest within the meaning of Article 21. But I think that case, if it would be reviewed today, it would have a different outcome, simply because countries have now accepted economic security as a concept that, you know, that I mean, they have put security to the word economic. And I think that's very dangerous, I think, for the trade system, because now anything that is labeled as economic security can also be used, can also be justified under Article 21. So that's very dangerous. But it can be, something can be done. So to go to the original question, something can be done. But number one, countries that do not consider that economic security is a security issue that should be governed by WTO rules, they should expressly mention this in the WTO committees. They should not securitize economic security, right? They should expressly say this is not a security issue, this is a purely trade issue, right? So these trade restrictions are imposed, they're protecting your domestic industry, they're capricious, they are in violation of WTO rules, they have nothing to do with security. They should expressly mention that. They should bring cases before the WTO, right? But if they don't do that, then that securitization narrative becomes mainstream. You know, it's adopted, and it just goes, it becomes viral, right? So that's the first thing that they would have to do. They have that, the country states have to express an opinion on this point. And then from a litigation point of view, well, it depends really on the facts of the case, whether something really amounts to an essential security interest, whether, you know, there is indeed an international relations emergency. You have to go through all the legal tests, really. I think that's it, no?
Yeah, I guess we have actually, I'm pretty sure, many more questions, and actually myself included. But we have some schedule also to catch up, and with that, let me, on behalf of the International Comparative Law Research Center, say thank you very much for your insightful and thought-provoking lecture, and also for the discussion. Thank you very much, and maybe some final words would be, especially for those who are less familiar with us, we are really happy to have all of you here with us, and please subscribe to our social networks. And well, we post news about upcoming events and things like that. So let's stay in touch. So thank you very much. Bye.